But first, I would like to welcome Seema Kennedy, Executive Director of Fair Civil Justice. Ms. Kennedy was a lawyer with Slaughter and May before spending 4 years as a Conservative Member of Parliament for South Ribble in Lancashire, during which time she held briefs on immigration and public health and was an aide to Prime Minister Theresa May. Since leaving Parliament, she has spent 4 years as a non-executive director of UK water regulator, Ofwat, and recently joined FTI Consulting's strategic communications segment as a senior advisor. But most relevant for our conversation today, since 2022, she has been executive director of Fair Civil Justice, which describes itself as a campaign to level the playing field for British consumers and businesses from the threat of predatory litigation. Seema, welcome to the Global Class Actions Symposium. Thank you for joining us today. For those not familiar with your work, could you introduce Fair Civil Justice and your specific interest in third-party funding?
Yeah, well, thank you, Andrew, and thank you for inviting me today. As you said, I think the debate around mass claims in the UK and the role that litigation funding has in it has really become more to the fore in the last year. And I think that actually there is a balance, there is some sort of middle ground, because I think from when I was in Parliament and had other roles where I've had people coming into surgeries and talking to me, and also working with businesses, I think there is a real delicate balance between enabling claims but also protecting consumers and productive businesses, and that's what Fair Civil Justice is set up to do. We want to promote faster and fairer alternatives to litigation, and when consumers do go to law, when there is a judgment, we want to see that they get more of the monies that are awarded. So we have spoken a lot around third-party litigation funding, but we're also very concerned about the opaque nature of some of the funding in the market, some of the operators, and this sort of drive to a really litigious culture. We're lucky to work with an enormous range of businesses, large and small, up and down the country, because they really see that their investment decisions are increasingly being influenced around that. And I do just want to talk about access to justice, because it is a phrase that is used a lot. It's obviously important and nobody would disagree with it, but I don't think you can draw a straight line between the number of people who are entering litigation and whether they have access to justice. I think you need to look at outcomes, and I think you need to look at all the other players who are part of the ecosystem. I think, litigation funding is important. We know that this is one of the biggest markets in the world, as you've alluded to. But what we think is that there needs to be some safeguards around it.
Okay, let's dig into that a little bit more then, because you touched on some of the concerns around litigation funding. And as I think you alluded to, funding in this country is quite well established. It certainly predates the opt-out collective actions regime, which is 10 years old. We've had litigation funding for commercial disputes, for some years prior to that, and is often used by companies or other individuals who are bringing single commercial claims or managing their balance sheets during long-running legal proceedings. So, how much harm is litigation funding doing here? Is funding as a whole a problem, or are there specific aspects of it that you're concerned about?
Look, very good question, and I think the idea that this has suddenly, I think there has been a massive growth of it because over the last 10 years. I don't think we've ever said that it wasn't there or that it doesn't have a role to play. But I think, and this is what the Civil Justice Council outlined very clearly, there are different parties to litigation who can use it. So I think it is important to distinguish between consumers and business use. And I think some of the egregious cases that we have seen, let's say the cavity wall insulation families and others, they are consumers who are not very sophisticated. I'm sure you're going to go on to discuss the recommendations of the Civil Justice Council review. It was an enormous piece of work, but I think it's really important to distinguish between businesses using it, sophisticated litigators, and the vast majority of British people who don't really understand what the role of the funder is. And that's because, as compared with solicitors, they don't have the same professional duties to a funded party.
But is that more of a communication or sort of education problem that can maybe be addressed rather than a funding problem, if you like?
Well, I think there's two sides of it, but if you look at most financial products are highly regulated. You know, if you're opening a bank account, getting in, insurance, the list goes on, and solicitors are highly regulated as compared with funding, which is still self-regulated. Yes, and we know that some funders sign up to a voluntary code, and that's welcome, but that isn't the same as actually being answerable to a regulator who's sophisticated enough to understand these products, like the Financial Conduct Authority, and who is answerable to Parliament.
Okay, you mentioned the CJC report. So for those not based in the UK, the Civil Justice Council, which has an advisory role to UK government, was asked to produce a report on the status and future of third-party litigation funding, and delivered its report this summer, back in June. That was quite a detailed report, which made a lot of recommendations, and you alluded to that. So what did you make of the report's overall findings? Obviously, there are many aspects, and we can't go to it in too much detail today, but in broad terms, it seemed to endorse litigation funding with some, if you like, light touch regulatory guardrails and some improved clarity. So were you broadly on board with those findings?
I think, first of all, we've got to think about, why did the report come about? And I think that it was brought about because there has been this enormous growth in litigation funding and a very large growth in class actions, which has brought the attention of government. So as well as the Civil Justice Council report, we've got the one by DBT, and we've got calls for evidence from the Solicitors Regulation Authority, and etc. So I think let's look at a bit of background. They, having sort of sat in the decision maker's role, I can see that they commissioned a report by some extremely erudite and experienced lawyers and academics, and they've come up with, I think, 58 recommendations, most of which we endorsed. Of course, we're not going to agree with everything, but some of the key proposals around mandatory disclosure of funding agreements, that I think is quite obvious, and when you speak to people who don't understand the market, they're surprised that that isn't there already, because understanding who the funder is and the source of funds, again, this idea about transparency, consumer protection, that should be at the heart of it. Capital adequacy requirements, because we have seen cases where funders haven't been adequately resourced, and that's a problem. Anti-money laundering compliance, again, this is just something that is quite straightforward, and I'm sure that most funders would also endorse. And the Standing Committee on Litigation Funding, we think that that's a good idea, because of course, as the market changes, there needs to be constant monitoring of it. There are some aspects where we've spoken to the Ministry of Justice, because we're not quite in agreement, but we know that government is taking it seriously, and we've seen that from ministerial statements. So
funding, although well established, and you talked about the rising cases in class actions, funding has had a bit of a lull in its market, or a bit more of a difficult market in the past couple of years, following the Supreme Court's 2023 ruling in the PACCAR case, which, in sort of brief summary, found that some existing funding arrangements were unenforceable. The previous Conservative government proposed legislation to address that ruling and reverse that situation, but wasn't able to do so prior to the election. And then the current government commissioned the CJC report, and that having been submitted, ministers have recently made some public statements along the lines of that funders will have to wait a while longer before there's any action on this. So bearing in mind, what you've said about the CJC report and the current situation we find ourselves in, what action would you actually like to see the government take on third-party funding? What measures would you like to see introduced?
Look, I think on PACCAR, it's totemic. I know for a lot of people this seemed, but all the stories we heard that everything was going to collapse and no cases were going to get through, and I think that we haven't seen that happen. So I know that that was the number one recommendation. Fair Civil Justice position is that you don't need to overturn it. We've seen workarounds in the CAT. But, we can read the runes. As far as we can see from what Minister Sackman has said a couple of times recently at the dispatch box, they will be reversing the PACCAR judgment, although not retrospectively. I think there's a very, and I also, look, this is an important issue. There's now everybody probably in the UK, everybody in this room is in at least 10 opt-out cases. There are many other people who will have signed up for other cases. We know from speaking to businesses that this is something that troubles them, that it is affecting their investment decisions, and that really impacts on the growth prospects for this country. And it's right that the government will take time to balance the rights of people to access the civil justice system, but also knowing that access to justice is for the claimants, but also the defendants. And they have to weigh that up against their stated aim, which is for the UK to grow. So we hope that we will be seeing further developments and legislation going forward. And I'm sure that as the Department of Business and Trade goes to the next stage, and we've had the call for evidence, once they're in a much more formal consultation stage, that will affect people's investment decisions, either by claimant law firms and funders, or by businesses thinking, are we going to launch this new product here? Are we going to employ these people here? Or are we going to choose another neighbouring jurisdiction which perhaps has a less aggressive litigation climate?
But I mean, if we're in a situation where, from your perspective, a lot of the CJC recommendations are reasonable and there's maybe actually quite a lot of common ground, and where you're working with an expectation that PACCAR will be reversed in some capacity, are you that far apart from the people on the funding side? Where's the area of difference? What's the thing that's going to affect that investment decision by the people you're talking to on the business side then? What's the thing that you think is going to, that needs to happen that would sway that decision?
I don't know how what decision government will take in the end. I don't know. And I think anybody who comes and says to you, I can predict what politicians are doing at the moment, that's a brave statement from what we've seen in the last few years. I think that for the businesses and the trade bodies, and I'm talking about businesses of all sizes, what's very important to them is having some transparency about who is funding the cases, and knowing that that sort of certainty is really important, and having the court understanding some of this as well, because I think what businesses find quite puzzling is that they're dragged through the courts for years and years and years up against their customers, and these are people that they have spent a long time building a relationship with, and then the settlement comes and the distribution rates are extremely low, and we have seen that in the Boundary Fairs case, in Merrick's, and we know that even in the cases where, as in Boundary Fairs, where the distribution rate was less than 1%, even on the best case, the claimant side had said the distribution rate would be between 10 and 20%, and the court said, well, I think it'll be about 10%. Well, and we know from other jurisdictions, like in the United States, average distribution rate is 9%. So where is for most people, that isn't justice. having such a low distribution rate. And I think we need to balance off and really think about who's benefiting and how is this benefiting consumers to have such a low distribution rate.
I mean, we've heard a bit this morning about some of the challenges of communication and settlement, and how also this is, so in relative terms and in the terms of legal regimes, quite a young regime. You know, we're still, Justin Goodman was talking this morning about how precedents are still being set and the regime is still establishing its feet and speeding up. So is this not more a question of communication and building the right structures rather than an inherent problem with the regime overall?
Well, I think the inherent problem is that opt-out is always delayed opt-in. You know, at the end, somebody's got to make a choice. So I think, again, I don't, and of course now we're hearing, oh, well, it's only 10 years. How much longer do we have to give it to run its course? But at the meantime, you know, at the same time, we've got businesses making active decisions whether to invest in the UK because of the investment climate. So I think government has got a choice to make on what sort of, how do we solve disputes. I think using a lot more alternative dispute mechanisms would be helpful, whether that be through ombudsman or, you know, some regulators or statutory or voluntary redress schemes. They can often be a lot less extractive and return a lot more value to consumers a lot more quickly, rather than going through litigation which takes years and is extremely expensive.
I mean, you've mentioned, you know, what businesses are looking for, and we've had a question in via the Slido app, and the audience here, if you have a look on your tables, there's cards with details about how to submit questions. So someone's asking about here, you know, because you've been talking about what UK businesses are looking for and what's in their best interests, but also investment decisions by foreign interests. So, you know, how are we to decide then between what might be best for UK businesses, particularly smaller ones who might themselves be part of a class, or the people who work at those companies might be part of a class, versus ultimately the claimants in these types of big claims that we're talking about are large US or other foreign corporations. Some of the, you know, the largest cases that have been here at the CAS are foreign corporations. So how do we balance standing up for the interests of UK businesses versus US interests?
Do you mean the claimants or the defendants? Because in fact they are on both sides, because the claimants are also funded
But
by large US hedge funds.
Are we seeing many big UK companies on the defence side? I mean, we're seeing a lot of cases against large US companies.
I think drawing this sort of, oh, well, you know, US against UK, in the end, if we believe in free trade and if we want foreign direct investment, I think championing the business practices of wherever people come from, as long as they're employing, you know, growing, innovating, opening factories, having apprentices, that's what we should be asking for, and that's spreading the wealth all around the country. I think concentrating on legal London, I think for most policymakers, they need to make a choice, because, of course, having a thriving legal market is important, and you know, it's a really important part of the economy, but there are other businesses who would be investing in other parts of the country, and this is an issue for them.
You mentioned earlier the Department for Business and Trade's review of the opt-out class actions regime. So, I mean, has Fair Civil Justice made a submission to that review?
Yes.
And is that something? And a lot of the claimants, or the claimant side people and the funders have published their submissions. You know, will you be able to publish that, or are you able to let us know some of the gist of what's in your submission?
I think the main thrust of what we have said is that the way that the regime is working does not meet the criteria of the initial impact assessment, which was, I don't know, in about 2012. I think there are considerable questions to be answered about certification. There are real issues with distribution levels, and I know people are saying, oh, well, it's because we've only had 10 years for it to bed in. But again, I mean, they are woefully low. If you look at, and we've seen judicial commentary in Spottiswoode, in Boundary Fairs, in Smith, in Merricks. So we don't think that this really meets the criteria of what it was set up to do. I think there's also there's basically a disproportionate risk to business without the commensurate benefit to consumers. And we also have real questions I think there's questions to answer about whether the idea of this sort of tackling anti-competitive behaviour is working. Just because the certification level, we don't think, it's too low. And I think what we need to think is, why do we have regulators? And we have regulators who are predictable, sophisticated, they are world ranked, then interacting with litigation, because it can really undermine regulators. And I think for businesses, they want something that's very predictable.
We've been talking a bit about the opt-out regime in total, but I want to bring it back a bit to funding. We've had one question in, which is about, we're talking in funding terms about claimants being more transparent about their funding arrangements. We've had one question about whether defendants should be more transparent about their budgets too. Certainly there have been some instances where there have been questions about whether the defence side has unnecessarily run up their legal fees. So should there be more transparency on that side as well?
I think, I'd say two things. I think everybody would agree that litigation is too expensive. And, there's been a bit of an arms race on that. But what I know from other jurisdictions where there has been disclosure of funding agreements, then the quid pro quo is there has to be some transparency about defendants' budgets as well.
Okay. And can you tell us a bit about maybe to come back to where we started? So fair civil justice, at its inception 3 years ago was billed as being launched by the US Chamber of Commerce, or its Institute for Legal Reform. So, and more recently is established as a registered company here in the UK. So who, if you like, are you seeing, and who actually is who owns fair civil justice, and who do you see as your sort of core constituency?
Interesting question. Again, I think what we see, we act for consumers and we act for businesses who are operating in the UK and want to do so in a responsible way. They want to support the people who work for them, their investors, their customers, the communities they support, and that's who we work with. So a variety of businesses, big and small. And of course, we're always talking to lawyers, to policymakers, just to sort of talk more about this issue, because funding, we recognise it has a role to play in the civil justice system, but we do think that there are questions to be asked about it, which is why we want to see more safeguards.
But can you be acting in the best interests of consumers when the origins of the organisation are with industry, with the...
But I don't understand are you saying that businesses don't like their customers, that businesses are somehow at odds with the people that work with them and the communities they support? I don't agree with that.
I don't think it's that businesses are necessarily at odds with their consumers, but clearly businesses are coming from the perspective of what's best for their business, which is maybe to have consumers in a certain type of relationship with consumers. And if what you're saying is you're looking for the best interest of consumers, should that be coming more actually from claimants, from consumer groups, things like that, rather than start from a starting point of interacting with big business, with industry?
Again, I suppose I'm somebody who believes in responsible capitalism, and I reject this dichotomy of big business and being anti-consumer. So I don't agree with that. But if what you're saying is you want to see all large claims brought by some sort of qualified entity, just a charity that would do it, rather than a claimant law firm and a funder, so that there would be no profits returned to them, I think that is something that we might be able to explore. So,
we've just got 30 seconds or so left. So, just where would you like to see things go from here, specifically with regards to funding? Assuming that the government does take some action in the near future, what would you like to see? Where would you like to see us maybe be a year from now if we were having this conversation again?
Well, I'd like to see more transparency. I want to see, I think, more a register of mandatory registration and regulation by regulator answerable to Parliament.
All right. Well, thank you for your time today. We could discuss this for hours. I'm sure some of the people in this room would like to discuss this for hours and raise many more questions. But thank you very much for your time. Thank you to those who sent in questions via the app. We're now going to move on to the second part of our funding double bill, where we have, so if I can invite that panel to head up towards the stage, we have Scott Hardy from Top Class Actions is going to be chairing this one, and he will come onto stage and introduce the rest of the panel. So if you could all thank Seema very much and welcome the next panel.